Okay, good afternoon, everyone. Can the attendees, if someone could put in the chat that they can hear, we just want to test one more time that the audio is working. And while we wait for that, we'll go ahead and get started. So good afternoon, everyone, and welcome to the O'Donnell Consent Decree public meeting. My name is Dr. Natasha Willis, and I am the Program Compliance Manager with the Justice Innovation Team at the Office of County Administration. For those of you who may be new to these meetings, following a class action lawsuit against Harris County claiming the misdemeanor bail system was unconstitutional, the parties involved reached a settlement agreement known as the O'Donnell Consent Decree. All parties recognize that the input and involvement of Harris County residents will be essential to meaningful and lasting reform and will be effective for ongoing system monitoring. As a result, we hold these public consent decree meetings. To read the consent decree, annual reports, access the monitor's website, or other related O'Donnell information, please visit oca.harriscountytx.gov. We are currently in year 5 of the 7-year decree, with this being the second public meeting of the year. Here today to provide an update on the consent decree implementation and an overview of the 7th O'Donnell Monitor Report are independent court monitor, Professor Brandon Garrett. Our deputy monitor, she's not here today, but she wished that she could be, is Sandra Guerra Thompson. Then we have Rachel Frazier with the Harris County County Attorney's Office, and Major Joseph Blenderman with the Harris County Sheriff's Office, and the Honorable Shannon Baldwin representing the County Criminal Courts at Law. After the updates, we will open up the floor for public comments and questions. With that, I will turn it over to Judge Baldwin.
Good afternoon, everyone. Again, my name is Shannon Baldwin. I'm the presiding judge for Harris County Criminal Court at Law Number 4. I'm also the presiding judge for all 16 of the county criminal courts. First, I'd like to thank everyone for being here. This is certainly important work that we're doing, and we appreciate your interest. I'd also like to thank the monitors for their continued work in documenting our compliance and progress, our justice partners who have been working closely with us in our efforts to ensure Harris County has constitutional bail system. Bail reform. The Harris County Criminal Courts at Law continue to be committed to ensuring safe and effective bail reform. Misdemeanor bail reform is designed to level the socioeconomic playing field. It ensures that no one remains in jail simply because they cannot afford to pay bail. Bail is not meant to be a tool of oppression, but a way to maintain public safety and ensure defendants who are presumed innocent under the law return to court. The focus is now on whether the person is considered a danger to the victim or the community, as well as their likelihood of returning for future court dates, not just if they can afford to pay. Appropriate bond conditions, protective orders, pretrial supervision, and other conditions are also used to mitigate potential risk with the goal of setting effective but not excessive conditions. Moving on to our case backlog. I have exciting news, by the way, to share with you regarding our misdemeanor case backlog. We have now cut the misdemeanor court case backlog by 71% since January of 2022, going from 24,000, thanks for the cheer, 24,457 to 6,903 cases across our misdemeanor courts. During that same time frame, we cleared over 156,444 cases overall, an average of 9,778 cases per court. Additionally, our average clearance rates have trended well over 100%, as high as 140% this April. We're doing this through our continued focus on best practices, increased efficiency, good leadership, and data-driven decision-making. During our last update in April, we reported a 65% reduction. Just 6 months later, now we're at 71%. Our continued steady progress serves as proof of our commitment to this issue. As to our domestic violence docket, again, exciting news to talk about for our domestic violence. We recently received additional funding to continue that court. We launched this specialized docket in January of 2023, utilizing an existing emergency response docket funded by the American Rescue Plan Act. Our goal was to bring uniformity to the domestic violence cases and cut the time it takes to dispose of them, which has been shown to improve outcomes for both victims and defendants. The daily docket, which is overseen by our dedicated associate judge, focuses on cases related to intimate partner violence, violations of protective orders involving firearms, and misdemeanor animal cruelty. In its first year, the docket was assigned more than 1,600 cases and disposed of almost 70% of them. The trend has continued into 2024. This program allows our courts to prioritize some of our most pressing and dangerous cases while also focusing on reducing our misdemeanor case backlog. We're pleased to have received additional funding to see it continue. We look forward to increasing the services and the resources through this court as well, upon also discussions for additional funding for that. In conclusion, as we move forward, we're continuing to refine our processes to support positive outcomes and increase efficiency. We're placing a strong focus on scheduling and discovery orders, firm trial dates, and using data to identify and address exceptional cases. We see these methods are making a difference. We're excited about the continued progress we're making and look forward to highlighting it in our next meeting. That concludes our update. Thank you again for the monitors, our justice partners, and all who attended today. I look forward to any questions. I will be leaving right after this presentation. However, I welcome any email questions that you may have. I'll answer them directly. And my email address is Shannon, SHANNON _Baldwin, BALDWIN @ccl.hctx.net. Thank you.
Thank you, Judge Baldwin. Professor Garrett?
Especially since you have to leave soon. Before you go, I just wanted to give the shout out immediately. The last time we presented, we described how, in terms of the data that we received from the courts, we'd seen this steady increase in the speed with which misdemeanor cases are handled. Speaking to the hard work that the judges have been doing to reduce backlogs and improve on anything before, in terms of how cases are processed and to reach the right result faster. Anyway, it's been 6 months, and the new data shows even more steady improvement in terms of the speed with which misdemeanor cases are processed. And obviously, there are some challenging cases that one doesn't want to rush on, but it's a noticeable trend, and we all within the system, and people like us as monitors, we understood that it wasn't just Harvey, but then the COVID pandemic made it very hard to move cases forward when trials couldn't happen. And we understood that there would be Herculean work needed to dig out from the backlog that was not the doing of anyone in Harris County, but it was larger events in the country that, every court in the country was shut down. But the hard work, we see it in the data on our end too, the hard work that has been done to really not just return to normal, but really we're now seeing, kind of case processing times that are, better than ever. And so I wanted to report what we're seeing, which is exactly what you said, but from our perspective, and want to compliment you all on it while you're still in the room.
Thank you. Thank you. Thank you. I appreciate that. Yeah. I'll relay the message.
Yeah.
Please forgive me.
But in terms of other updates, really what I have to share is no different than what we said when we last met. I also want to thank, by the way, everyone who attended and some of you attended, who are here today, our community event in the evening. We had always wanted to have events, not just here downtown, but events in other parts of Harris County, since obviously the driving distances are long and parking downtown isn't always easy, especially on days like today when celebrities are coming to town. But the pandemic also didn't just put a damper on the ability to move dockets forward in our courts, but it also, less important, but it had put a damper on our ability to have public meetings that were more accessible to the Harris County public. And so we're really grateful to you, Natasha, and for all the work of community partners, including the Texas Jail Project, who put on a really wonderful event in the evening yesterday. And shared some really, really moving films, people sharing their freedom stories about what it meant to them personally to be able to readily return to freedom because they, under these reforms, were able to have a GOB and to not be held due to inability to pay. In terms of our work, we will have a typically lengthy and detailed report that we'll file with Judge Rosenthal next March. So this is really an interim meeting. But we did run the typical data that we received from the courts to see whether anything had changed during the most recent time period. And really, the numbers look largely the same, except even more improvement in terms of case processing, like I just mentioned. That continues to look better and better. And then it was wonderful to hear from Presiding Judge Baldwin about the hard work that makes that possible. But in terms of looking at the 2024, this past year, the types of misdemeanor charges haven't changed noticeably. It looks the same as 2023. The race, ethnicity, the demographics of people arrested for misdemeanors looks the same as the year before, no particular change. In general, we've seen, a decline in the share of misdemeanor cases that ultimately result in a conviction. And so it's, about all percentage results in an acquittal. But that hasn't changed, this year as opposed to the year before. It's been really the last several years that the dismissal acquittal rates have been, higher than they had been, because most people pleaded guilty in the pre-bond reform era, where if they couldn't afford their bond, they'd be held in the jail and often, would plead guilty without meeting a lawyer. That was very fast case processing. People would plead guilty in a couple of days, but it was, found to be unconstitutional, and for some good reasons. People hadn't met with a lawyer, and no sort of work had been done to adjudicate their case. It looks like we only have, first half of the data for this year that we've examined so far, but the first half of 2024 looks very much like 2023. It looks like it will be, about 41,000 and change misdemeanor arrests, which is quite a bit fewer than it had been before these O'Donnell reforms. Back in 2015, it was about 50,000 misdemeanor arrests. Now it's a little over 40,000, but that is a meaningful decline in terms of the size of the misdemeanor footprint in Harris County. Apart from that type of data, there's a lot of hard work that's being done to implement different parts of the decree, right? Rule 9 and the rules around who goes to a bail hearing, who receives a GOB and is released after booking. Those rules are only part of the reforms. And like Sandy and I have been saying for some time, there's a larger architecture to this consent decree designed to improve the way misdemeanor cases are being handled across a number of different dimensions. The bail reforms didn't, get completed in 2019. And if they had been, then they wouldn't have needed us, which might have been nice. It would have been so quick. But some of these larger improvements have taken time and have been worth the time. We described last spring how, due to a lot of work, particularly by the county attorney's office and also our district clerk and a number of others who provided a lot of advice and technical support, Universal Services, Sheriff's Office, we now have a portal called My Harris County Case. And at myharriscountycase.com, people can figure out when they next need to be in court, which wasn't so easy to do before that system was created. There's nice signage and flyers. It's just if people don't know how to reach their lawyer or don't know what's happening next, it's much easier to find out what's happening next in their cases. We have more things coming up in the year to come. We're looking for new parties to do training for stakeholders. We continue to watch videos of bail hearings. We continue to examine, and we'll have more to report in our next report in March, the costs and cost savings, cost estimates surrounding, what the county spends on different aspects of the bail system and how that has been affected by these different reforms. We shared some analysis in the past, and we have much more complete analysis that we're working on spelling out now. And finally, we really welcome feedback from everyone here and from the community at formal public meetings. That may not always be the place, but we've gotten really helpful questions at these events in the past. You can also ask questions anonymously on our website. We are doing, with some outside funding, a small number of interviews of people in Harris County who have misdemeanor cases. We would love to hear from people describing their experiences. They don't just have to be complaints; they can be positive experiences. Those are really wonderful to hear about too, of course. And that's some of what we've heard from people who wanted to share their experiences. That's really all we have in updates. Again, we'll have a much more detailed report in March, and we know that people are trying to get out of the path of the Queen Bee. But so we understand that we appreciate that you're willing to tackle downtown traffic to be with us here this afternoon. But mostly we have continued good news to share. Not a lot of changes or updates, except to the extent that there are a few additional positive observations which I shared and which go along with what Presiding Judge Baldwin shared as well. Thank you as always.
All righty, Attorney Frazier.
Good afternoon.
Oh, make sure you turn your mic on.
Good afternoon. My name is Rachel Frazier, and I'm here on behalf of the Harris County Attorney's Office. Our role is to provide legal counsel and assistance as needed to assure compliance with the consent decree. We also advise on other issues as they arise and is needed. We look forward to continue assisting to implement misdemeanor bail reform in Harris County and to ensure that everybody's constitutional rights are upheld while also ensuring community safety. Thank you.
Thank you. Major Blenderman.
Good afternoon. So mainly the sheriff's office is in charge of processing, people that come into our jail. And I'm actually the bureau commander over what we call now the Detention Management Bureau. It used to be called the Justice Management Bureau. And it might get changed back to that because we've brought the court division back under our umbrella, under our bureau. I was previously, about 6-7 months ago, the captain over the court division. And then before that, most of my career has been in patrol. But as far as misdemeanors, we process in 2024, we process about 300 misdemeanors a day. But half of those are released within just, probably 14 hours. They bond out or it gets dismissed by probable cause court or something like that. The average process time for a misdemeanor is about 14 hours. In 2024, our felonies were 47%, and our misdemeanors were 42% of the people that we brought into our processing center. The other was miscellaneous, like 11%. Those were the Class Cs. But the misdemeanors, that means that's almost 36,000 people. Harris County is the third largest sheriff's office and county in the nation. And so our inmate population is approximately 9,800 inmates. And we outsource. I'm over the outsourcing also. So we have we had 4 facilities. Now we have 3. We're getting ready to get another facility. What these are off-site institutions where we can house inmates. And so that takes the load off of the jail, the population. Let's see. We have also a dashboard that tracks, the number of booking and receiving and intake, and people are approaching the 48-hour rule. So it's a real time, and so we can keep track of that. So we can make sure that if we have people in there too long or in the choke points of our justice processing center are usually in our medical. We have a full medical staff there, including providers. And one thing I'd like to attest is that the sheriff's office, medical is probably one of the best as far as, so we take people that have come into our facility, and I'm probably going off tangent here, but they get access, mentally, mental health and physical health. And so if they need medication, they get medication, they get checked out. If they're too ill to be in our facility, they get transported to the hospital. So some of these people have never even been to the doctor. It's been a long time since they've been to the doctor. So we definitely do try to take care of everybody and all their needs. You know, one thing we do when they do bond out or they are released, we have resource teams, especially that help out the homeless or people that are indigent that need transportation. We have transportation vouchers. We have mental health resources that even though they're bonded out, we want to make sure before we release them, they have the means to get home or, you know, to get through to their destination. So we just don't, you know, leave them out on the street or anything. We try to, you know, make sure they, just like they came in, when they get out, they can have the tools to get out of there. And they do have access to the public defender's office and, you know, and like we talked about on the medical end of it. But this is probably all I have right now. Like I said, you know, the sheriff's office is mainly over the processing of it. And on a personal note, I think this is a great, you know, organization or purpose. You know, many years ago, I won't tell you, well, I'll tell you, about 34 years ago, I was actually a bailiff in County Court 13 and District Court 208. And I saw people that actually pled out to cases that could not afford a bond. So I think bond reform is good. It has its purpose. That's all I have.
Thank you so much. Thank you all for the review. We will now begin the question and answer portion of this meeting. We'll start with in-person questions and then take questions from our online audience. For those in person, if you have a question, please come up to the podium in the middle and state your name and affiliation in the microphone before asking your question. And then when we get to the online questions, again, if you have any questions, please either type them in the chat or the Q&A feature. And you can list your name, affiliation, and then I will read your question out loud for the panel. So does anyone in the audience have any questions? Great. And same thing, if you can just turn on the mic.
Turns green. There it goes. My name is Mario Garza. Excuse me. I just have two questions. How is the Fifth Circuit rulings in Daves versus Dallas County and O'Donnell kind of, I guess, being that in some places of O'Donnell and Daves being similar, how has it impacted the legal implementation of O'Donnell? And that some of those issues in those cases in O'Donnell and Daves have been reversed. Second, O'Donnell, while it was meant for misdemeanors primarily, in some recent, all through last year, I saw felony cases that were given PR bonds or GOB bonds, even though Russell versus Harris County, which was similar to O'Donnell, was still pending. So I was just kind of curious how that happened. Just two questions. Those are them.
Sure. I mean, our role under O'Donnell is limited to misdemeanor cases only. If a felony judge gives a PR bond, that's based on whatever rules they're following, their discretion.
But the magistrates?
And similarly, you know, when we listen to bail hearings, right, the magistrates are very, I always listen to the admonitions they give at the beginning of the hearing. And every time I've listened to them, and I think I've, you know, seen all the magistrates give their admonitions, they're very clear about, you know, if this is a misdemeanor case, Rule 9 applies. And these are the standards that apply in a misdemeanor case. If it's a felony case, they have a different set of instructions. It's really, although the dockets may include both types of cases, when I've heard them describe it, they're very clear that there are somewhat different standards that apply when it's a misdemeanor case versus a felony case.
Thank you.
But that said, I don't then listen to what happens during the felony hearings. We don't get data about, you know, felony bail. That's not our mission or our role. But in terms of, you know, we've been asked before about the Daves case. That was, for those of you who aren't familiar, that was a case that was brought challenging pretrial bail practices in Dallas, which is, you know, different city, somewhat different system. some rulings were made by the Fifth Circuit having to do with
Standing
standing and immunity doctrines,
and jurisdiction as well.
So interesting federal court doctrines. But the O'Donnell decree is a finalized consent decree. It was, settled by the parties some years ago now. So it doesn't affect, a prior judgment. And there were rulings made by the Fifth Circuit in the O'Donnell case itself, right? The case went up to the Fifth Circuit twice, I think. I wasn't involved in that litigation. I'm not one of the parties to the lawsuit. But, I think one can always speculate, well, if a case had gone to the Fifth Circuit today versus 10 years ago versus 5 years ago, today, would the litigation have turned out differently? And would the parties have reached the same settlement that they would have? But the parties did reach a settlement in this case. And so, rulings in other cases don't affect our work. In terms of the consent decree stands unless the parties or the judge modified it at some point.
There was some possibility that it might be set aside in the event because the county judges were considered state actors and not policymakers through the reversal. So since that happened, the attorney general wasn't made a party to O'Donnell, which means that possibly, I'm not saying, again, I'm not an attorney, but possibly that the consent decree could be set aside because the attorney general wasn't included as a state actor in the original lawsuit of O'Donnell. So I'm just curious as to what your response might be to that.
In general, the law of judgments remain final, and it takes a lot to undo a judgment. Okay. It's not impossible certainly parties could agree to modify a judgment. And even there, a judge might say, like, look, we negotiated a settlement in this case. We don't get to revisit it. But for parties or non-parties to alter a consent decree, it takes a very high degree of changed circumstances, and it is not often done, and particularly when you have litigation that went on for many years and settlement that was negotiated. There had been consent decrees like in the school desegregation setting where over decades a consent decree might be modified because the parties negotiated with the understanding that changed circumstances might result in changes over a much longer time period.
I think Harris County was under one of those, under Ruiz versus Estelle unit, when they had to modify the prisons in Texas because of that. There was a 30-year consent decree that was entered into. So yes, sir.
Also, federal law regarding prison consent decrees changed with the Prison Litigation Reform Act. Mm-hmm. So there's some situations like that.
Thank you for your answer. Thank you for that. That's all I have. So
great. Thank you.
Hello there. I was there last night at the screening. My name is Sarah. It's really great that we're gathered here to talk about this. My question is, can you say more earlier, Mr. Blenderman, about a new facility? Why would we need a new facility if bail reform is working? And right now, the jail dashboard shows over 500 misdemeanors as leading charges. So can you explain why we still have so many misdemeanors? Thank you.
Well, all we do in the sheriff's office is process them in. We process, we take all the agencies in all of Harris County, and there's multiple agencies. 65% of the arrests that come in are from HPD. So I can't explain to everybody what they're arresting for or what the charges are for. But those are the numbers that come in. Your other question was a facility. So we're under the Texas Jail Commission as far as the max amount of people we can have in our facility. So when we get to the limit, our limit probably with the Texas Jail Commission is probably around close to 10,000 with the number of beds that we have in our the detention facilities that we have down here. So through their permission, and we get inspected by the Texas Jail Commission constantly, is we've been able to outsource. So the outsource is a jail facility. Sometimes it's a private, sometimes it's a public. And they've been inspected before we go out there and approved by the Texas Jail Commission. And so we transport some of our inmates that are in here for a while and their court hearings are a little ways away. And so we house them off to give, the facilities that we have a little space. And so like right now we have about, I think I said we have about 9,800 total inmates, and probably there are about 1,500 that are housed in the other three facilities. So we're down to probably about 8,200 that are actually in the facility. So it gives us a lot of breathing room for the comfort, if you want to call it comfort, in a jail, but also as far as the staff and everything.
So then what about the new facility if we're creating space in what we already have?
Building a new facility?
Yes.
Yeah, I have heard, I'm not privy to that, but I've heard that we are contemplating a new facility here, either in the downtown area or in the Harris County area, so we don't have to do this outsourcing.
Do you know when?
I don't. I'd be making it up if I did. Like I said, that's really a commissioner's court and the sheriff and some of the assistant chiefs. They make those future plans in our budget and stuff like that. But I have heard the talk that that's what they would like to do because, we're spending money housing them in these other facilities. Now, that'll cost us and the taxpayer money to build a facility, but I think it'd be a lot better to keep them as close as we can. Although we have buses on the road 7 days a week that are going back and forth from the facilities.
Well, my opinion is that I think the outsourcing is ridiculous, but thank you for sharing. Thanks.
Yes, ma'am.
Anyone else here in the room that has questions before I go? Okay.
Krish Kundu, I'm the co-founder and director of Texas Jail Project. Major Blenderman, I had a comment and then I have a question. So you mentioned that we're outsourcing just so we can have more breathing room, but you're outsourcing because we can't staff 1:48 as per the jail commission. That's a chronic issue, the staffing issue. We're not outsourcing because we don't have beds. We're outsourcing because we can't meet the state mandated staffing ratio of 1:48. Which, being a chronic issue, we are not going to be able to fix anytime soon. So that's just a comment on what you said. But my question is, on the jail data dashboard for at least 3 months now, by leading charges, we still have a total of 749 misdemeanors if you add up all the A, B, C misdemeanors. And I'm wondering why we have that many misdemeanors in our jail, despite having had misdemeanor bail reform. And then my last question is about the average length of stay. Could you share any data we have on the average length of stay for people in our jail? Thank you.
Okay. Again, the misdemeanors, I can't control the court system. I mean, the only way the misdemeanors will go away is if the charges are dismissed or they go to court and they're dismissed there or they plea out. And then, but they normally do county time in the jail. So usually and mostly misdemeanors are county time. So if they get sentenced to 90 days or 120 days or whatever, within about a 2-year period, they stay in our jail. So a lot of them, the misdemeanors are serving county time. I don't know if those misdemeanors are like pending court, or I'd have to do some research, or, that have already been sentenced and they're serving county time. Again, the outsourcing is, it is because we do have a max amount of beds we can house down here. Staffing, everybody has staffing problems, but, we're constantly hiring, and I think we have a good amount of staff. We definitely have enough to meet our needs, and so I think did I answer all your questions? I think there was one more.
The average length of stay.
Average length of stay, I'd have to get back with you on that. I'll shoot my lady that's over our offender management system a quick, just on misdemeanors.
On everything, but misdemeanors would be helpful.
Okay.
Thank you so much. I'm going to jump to some of the questions in the chat. So Andy Khan is on and has asked, what offenses are not eligible for a PR and or a GOB bond?
So, under Rule 9, GOBs are available for misdemeanors that don't fall into 6 carve-out categories. And so in those 6 carve-out categories of cases, there is a bond hearing where a decision is made about whether a PR bond is appropriate or a secure bond is appropriate and what conditions are appropriate. And so those 6 categories include domestic violence, family violence, repeat DUIs, violations of bond, probation, parole. And so in those carve-out categories, there's a bail hearing. And so, but nothing is categorically requiring of or ineligible for a PR bond, right? There's a decision made there, which would then be reviewed by the judge. What type of bond is appropriate in those carve-out cases? And we certainly, like I mentioned, we watch videos of those bail hearings. They aren't the 30-second hearings that you'd have under the old days where you just look down a cash bail schedule. It wouldn't make a decision about what public safety demands in a particular case. Now there's a more extended conversation where the prosecutor, defense lawyer, and the magistrate's asking questions. What is appropriate? What does public safety demand? Is there a public safety concern here? And what's the right bond? There is, but that's in general how the structure of things under Rule 9, right? There are cases that are carved out because these are categories that are more public safety salient. Those go to a bond hearing where the magistrate hears the evidence as to public safety and flight risk, makes a determination, and then there is a next business day review by the judge if the person wants to challenge a secured bond that's set in the case. And obviously the judge can revisit conditions or bond at a later time as well.
And I think that sort of also answers his follow-up, but just in case you have anything else to add, he says, what should the protocol be if someone who is released on a PR, GOB on an offense not entitled to them?
So I'm not sure exactly, not totally sure what the question is, but if someone was supposed to get a GOB but didn't, or if someone was not supposed to get a GOB but did, I assume it's referring to the latter type.
Yes.
Either way, if an error is made, a judge can correct that error at any time, or a judge can not change the type of bond, but can change the conditions or change the bond amount. And so, obviously the judges have dockets, many times during the week, and we certainly see bail reviews happening. And sometimes it's because an error is brought to their attention, but sometimes it's because conditions change and they decide that more conditions are needed, that the bond type shouldn't change, but more supervision is needed. Or sometimes it's that, no, we don't need the protective order because this person is living in a very different part of town. We're no longer as worried. There was some really noteworthy work that was done, and there was a study done by Harvard Kennedy School folks where some of the judges here in Harris County implemented a program where they would automatically review conditions and consider whether it was appropriate to step down levels of supervision if someone was succeeding with the conditions that they had initially in a case. And so that it was a programmatic review of bond conditions, even if the attorneys themselves weren't coming to the judge saying, there's an error or please modify the conditions. And they found that program of regular review of bond conditions was good for public safety and also, produced real cost savings because pretrial supervision isn't free. There can be real costs associated with it. If it's necessary for public safety, then it should be done. But if it's not necessary, then it's not a good use of resources. And so I think there are good examples in Harris County of important work being done to think about, what is the role of the judge in assuring that there are the right conditions in place for community safety but it's something that a judge can revisit at any time.
Awesome, thank you. Okay, there's two-part question from Jennifer Canales. And so this is just in reference again to the new facility. And so she states, it is my understanding that Harris County residents are outsourced to other states due to staffing issues, which we touched on a little bit within our current jails. So now that a potential new facility is in the works, she wants to know, how has the county addressed the staffing issue to ensure we're not wasting taxpayer dollars? And then also, do we know how many people will be housed in this new facility? And I just, to my understanding, I don't think any of the panelists actually will be able to answer that. As they stated earlier, that's kind of going on between not only the commissioners court, but also a particular group. And so what we can do is try to get some of these questions answered for you from maybe that group, unless, I don't know if anyone in the audience that works with that group would know, but
I certainly can't answer that question.
yeah, I was gonna say.
But I guess what I could say is, I think, you would agree that before these reforms took place, there were many more people in the jail and misdemeanors. It was more like 3,000 or so at any time. And so that's no longer the case. That didn't pursue, those beds aren't vacant though, but other things changed in the system. The space clearly was taken up by more felony cases. I guess if the hope had been that when these reforms took place, we would be emptying out a third of the jail, and that would be remarkable to create huge room. Other things changed in the system, and so we haven't, that didn't occur. That said, if the switch was flipped and we didn't have a system where people could have these more public safety and fairness oriented decisions made in misdemeanor cases, I can't imagine what kind of a crushing load it would be if we had thousands of more misdemeanors in the jail as well, given the demands that we have. So although we didn't have as much space empty in the jail as might have been imagined when these reforms took effect, back in 2019. Still, like the JPC, the work of the sheriff's office would be very different if we were back to that world where we had thousands of misdemeanors.
Yeah, just to reiterate, I have not, I want to make it official, I have not heard of any plans to build. I've heard rumors that people want to build another facility, but we have to understand that, back in 2019 and it started in Harvey and then COVID, what happened was, the court system was well affected, as we all know. And so that's where the backlog up into the jail comes. That's why we have the population that we have. And the court division and the district attorney's office are working tirelessly to knock these cases out, just like the judge mentioned earlier when we began. They've knocked a tremendous, number of cases out, and they're continuing doing that. And they just opened 3 new felony courtrooms, just opened about October 1st. And so we're pushing, I've been told that they're, of course, pushing the workload into those courtrooms, and that will help, reduce our population in the jail. To answer your question earlier, though, the average misdemeanor is 38 days in the county jail. The outsourcing, again, we have staff, we have enough staff, and we're constantly hiring people. I think it's an exciting career, and we also welcome anybody who would like to make a tour of our facility. We have tours. A lot of times they're professional tours, but we open up to the citizens. There's just a protocol you have to go to do that. But if you ever like to tour the facility, we can make that happen also. But anyway, that's as far as our understanding as far as any new facility. I'd like, she said that, that's above our area right now.
Mm-hmm. Thank you. Okay, so this is more of just a comment from Deborah Smith, who appreciates the work that is being done so far, as her family has experienced tragedy, unfortunately. And she says, although she cannot bring her daughter back, she, because of not having had an attorney on her case, which is also something that, with O'Donnell, we're addressing just as far as maybe more early appointments, but she just wanted to express that. And so there were a few follow-up questions. Sorry, there's like question and answer. So back to Andy Kahn. So domestic violence cases are eligible for the above if approved by a magistrate. But Brandon, I think you just said that's one of the carve-outs, right? So that's one of the ineligible.
So domestic violence, right, ineligible for a GOP, but a magistrate would decide, and then a judge would review whether the appropriate bond is a personal bond, secured bond, what amounts, what conditions.
Okay.
Yeah.
And so then he states if someone finds out that an individual was not eligible for a PR bond, should the judge be contacted?
Yeah, I mean, I guess, and certainly the DA or the can reach out to the judge at any time and ask that bond conditions be reviewed.
Okay.
Something for the litigants in the case to I mean, obviously the judge needs to have a hearing and allow the litigants to make their case about whether bond conditions should be changed or not. You shouldn't be changing someone's bond conditions without a hearing where counsel can weigh in. You don't want ex parte decisions being made, but that's something that, and that's also one of the important fairness protections in this consent decree, that there's an opportunity to have an next business day review before a judge of the initial bond setting by a magistrate.
Okay. Is there data on how many PR GOB defendants have forfeited the above and are currently wanted for bond forfeiture?
Yes, we talked about that in our last report. And in general, let's see. Looking for this. Looks like there's been a gradual decline in the bond failure rate since 2018. I don't have the more detailed figure in front of me, but there looks like from 2018 to present, the last 6 years or so, there's been a steady decline in the bond failure rate. Bond forfeiture, I'm not sure that is a category in the same way that it was before O'Donnell. I mean, the rules changed for what it means to fail bond. It was more just sort of discretionary, and it would vary a lot based on judge before Rule 9 was adopted. Now there's a clearer procedure for hearing from the parties and making a finding that someone did something willful to violate the terms of bond. And so it's bond forfeiture, bond revocation, bond failure all still reflect decisions by a judge that the terms have been violated, but the rules changed in 2019 and were reflected in a new process where there's a common procedure judges follow to decide whether it's been shown that someone willfully failed to comply. There's also a difference now where there's a new set of rules, not that new now, but they've been around for several years now, around court appearances, where they're just clear definitions so that people can know, like, are they supposed to be in court, or is this an appearance that the attorneys are supposed to handle? We still, at least the last we looked, we actually still see people over appearing, people appearing for for events in court that the client actually didn't need to be there for. But there are some settings where the person needs to be there, and especially, if it's something important, like say you're discussing a guilty plea, whereas there are other hearings which are about discovery or scheduling where it's not required, and judges can designate which type of setting it is. And so that's also something that's changed. There's more clarity around when are people supposed to be in court, and when are these events in court that the lawyers are handling, but the client doesn't need to make the trip downtown for.
Thank you. So there's some interest as far as the tour. So Major Blinderman, how can someone schedule a tour for the facility?
We'd have to call our Justice Processing Center, or, you can call any of the jails they have, 1200, 701, and just ask for the administration office. And they'll put you in contact with a sergeant that will kind of coordinate that and what the recommendations are and requirements.
Awesome. Okay, so there's also just a few folks, I believe B. Adams. So I think we've kind of discussed already the staff, at least again, this particular panel would not be able to answer that. But if you are able to leave your email in the chat, we will try to follow up with you to get you some additional answers on that. I think there's, again, just in the chat, a lot of folks expressing concern about building the new facility, and just the question of, okay, they're hearing that there's a staffing issue, so building a new facility and having to get staff doesn't make sense, but definitely a need and desire to stop outsourcing. So let's see. So then just also, again, some comments, wanting to see more advocacy organizations working with the mentally ill inmates. And I think another concern, and again, for those that may be involved in this is, again, building another facility doesn't seem to be the best, or people disagree with that because increasing capacity beyond what you can medically take care of and staff supervise. And so let's see. Wanted to make sure we get everyone's.
Yeah, can I say something real
Yes.
quick? So I got to just reiterate, there's no plans that I know of to build a new facility. I've heard rumors, like we all hear rumors, but the more the courts reduce the population of the jails, then there would be less need to build a facility. If there was even one plan, which I don't know if there is, I haven't heard. It's just rumors. The other thing is the outsourcing. The smaller the population of the jail goes, then the outsourcing goes away. And, we do not have a staffing problem. We're always hiring, just like nutrition. We have 5,000 employees. So like anything, people come and go, but, we're fully staffed. Just want to make sure that's on the record.
And I know there's a question, and again, this may not be kind of, again, the panel or the platform, but I know that someone is saying, one of the major issues for bail reform in Harris County is the conditions in the Harris County jail and inmate deaths. Why has the Harris County jail not put on a statement about the death of Jalen Anderson, and who was pre-trial and outsourced to Louisiana? If there is a statement, where can that be found? And I will be honest, V. Adams, I feel like this is definitely even still maybe, even if you do, it could be a question for Commissioner's Court, and I'm sure they could direct you to the appropriate team. I know this is definitely still just a question of concern, and I think even kind of thinking about our next meeting, having like a list of contacts for individuals, because again, some of the panelists may not be able to answer these particular questions, but unless anyone has anything to state about that, I may read the next question. And let's see, we're going to take the last one. Okay, yes, thank you, Deborah. We did hopefully clear that up. And then last question, how can I find out how many defendants are wanted for failure to follow bond conditions and have a warrant out for their arrest?
So we do report on numbers of people who are have a follow-on arrest. And those numbers, the numbers have declined. And the rate of rearrest has stayed the same for years and years and years at this point, which is good. It's positive news. In terms of whether a rearrest was due to a failure to follow bond conditions, like I mentioned, we've described the overall bond failure rate, which has been declining since 2018. We don't have information about what particular conditions were found not to have been complied with or what the reasons for the failure were. And so it wouldn't give particularly detailed, I guess, information in response to that question. So we know that the trend is positive and not concerning, but we can't speak to particular findings. Now, in any particular case, to see why did the judge decide that the person didn't comply with the bond conditions? I mean, there's an order in any particular case, which you can look up on the district court website, and there will be reasons given, and there will be a PDF there where you can look at the image of the court's order and see what the judge decided in a particular case. And certainly, I've seen those orders, and the reasoning is usually not. These aren't like long like U.S. Supreme Court opinions, but they'll say what the reason is. So for particular cases, there's obviously transparency. This is a court system; you can look up the orders, but we don't have like data distilling that text. So that might take some interesting analytics. What we have done, like I mentioned, is just look. Well, what are the trends in terms of the percentage of cases where someone is found to have failed the bond conditions?
Alrighty. Well, that concludes our meeting. Thank you so much for those that attended in person and online. For those online, there again are some questions that may not be for this particular panel, and I'm sharing my contact information so that we can get you connected. But again, Major Blenderman, Professor Garrett, and Attorney Frazier, we thank you so much for being here. Thank you for those who have joined us in the audience. Everyone get home safely. Thank you.
Yes.